Hi, Dustin.
Hey, how are you doing, Mark?
Good. Nice to meet you.
Nice to meet you.
I just gave Anders the rundown, but we just went live so that the attendees can join us.
Okay,
We'll wait 2 or 3 minutes and get a good crowd, and then I'll introduce Anders and we'll go from there.
sounds great. Thanks.
Thank you. Nice to meet you.
Nice to meet you.
For anyone just joining us, we'll wait another minute or two to let some people join, and then we'll get started. Hi, Kristen.
Hi, Mark. How are you doing?
Good. How about you?
Good.
I don't know if you've met Anders or Dustin before, but they're both.
Yes. Not Dustin, but I know Anders. Hi, Dustin. I'm from Disability Rights Ohio.
Nice to meet you, Kristen.
You too.
I think we could probably wait another 30 seconds or so and then should be able to get started. Okay, well, welcome everyone to the Special Education Legal Clinic. Today we have a presentation by Legal Aid of Southeast and Central Ohio, otherwise known as LASCO. This is going to be presented by Anders Miller, who is here, and Dustin Richardson, both from LASCO. And the title is Attendance, Truancy, and Discipline. And this is part of a series that we're offering, Intermediate Advocacy Series. And we're about midway through, and I think it goes through August even. For those of you who've signed up, you know you've signed up at lawyersforstudents.com/legal clinic. That's where you register for any of the workshops, as well as the individual guidance sessions that we offer afterwards. Those are in individual Zoom rooms separate from the workshop. And so we'll have those immediately following. For those of you who signed up, you'll have a link separately from this one for those individual guidance sessions, and I'll be managing those today. And a couple things before we get started. We do have closed captioning available at the bottom for individuals to click on the link and use if you'd like. And we will also have a Q&A throughout the course of the workshop. And so please do use the Q&A as opposed to the chat, if you can remember that. And while the presenters, Anders or Dustin, while they're presenting, some other of us, the panelists, will be trying to answer questions in the Q&A if we can by text. And if not, we may pause the presentation and pose those questions to the presenter. A few other things: you can sign up for all the workshops, any or all of the workshops, at the same link. I'll provide that in the chat box, as we get started here. The presentation or the slides are available. If you'd like, we can send those out. If there are any requests, we can send those out after the workshop itself. I think that's everything. And again, if you have any questions, please put those in the Q&A. And without any further hesitation, I'll pass it on to Anders Miller from LASCO.
Thanks, Mark. Well, good morning, almost just afternoon, everybody. Hope everyone's week has started off pretty well so far. My name's Anders. I'm from Legal Aid of Southeast and Central Ohio here with my colleague Dustin, who will introduce himself in a minute. And we're speaking about attendance, truancy, and discipline for today's legal clinic. We are both staff attorneys at Legal Aid. We do education work along with, I do also domestic and reentry, and then I'll let Dustin introduce himself.
Yeah, I'm split between two areas as well. So education and then also housing, primarily tenant advocacy work. And then my background, I've been with Legal Aid for, I guess, right about 3 years now. Before that, a pandemic sabbatical driving across the country in a travel trailer. And then before that, I was a criminal attorney, not actually a criminal, but an attorney practicing in criminal law. Did criminal defense for many years, and then before that, at prosecution. So bring a little bit different background in terms of my experience set than a lot of folks in the legal aid community, and hopefully provide some value in that regard.
And for me, my background prior to going to law school and was being a 10th, 11th grade English teacher at Franklin Heights High School here in Columbus, and really wanted to support kids from outside of the classroom, just not in the role as a classroom teacher. And so decided to go to law school and do this area. So I'm really excited to have everybody here. And please feel free throughout the presentation here, go ahead and put any questions you may have in the chat. We're going to try to keep track of that and answer any questions that you have as we come up. And then we're also going to have an opportunity for you to ask questions or provide some comments at the end of the presentation too. So don't feel like, if you feel uncomfortable interrupting us, first of all, don't feel bad. Go ahead and interrupt us. It's great to have that engagement, but also there will be an opportunity at the end for you to talk as well. So a little bit of information about legal aid itself before we go into the actual goals of today's presentation. Legal Aid of Southeast and Central Ohio, or LASCO, is a nonprofit law firm that provides civil legal help to low-income clients in Central and Southeast Ohio. So basically, we serve clients who are around 200% or below the federal poverty line, with some variation based on different grants we get and different income streams like Violence Against Women Act, or there's also housing funding that Dustin gets from the city. So there are a range of ways to qualify for our services, but the main one is being around 200% or below the federal poverty line and have a civil legal issue. So we do not help with criminal law. So if you're facing a traffic ticket or have been arrested for something, we're not necessarily going to be the ones to help on that, but we help with the civil aspects of things like consumer law, housing law, education, and those areas. So today, what you're going to really hopefully understand and reflect on are, you're going to understand how particular laws related to attendance, truancy, and discipline impact your students and your own families. And then also reflecting on how those laws should shape your decisions regarding those children's education as you're deciding what you want to do when you're in certain circumstances. So we're going to go ahead and we're going to start with school attendance here. It's not only a right, but also it's an obligation. And so in Ohio, attendance requirements are that all kids in the state between the ages of 16 and 6 and 18 years old attend school. And then if a child has a disability in the state, those primary and secondary education rights extend to 22 years old beyond the 18. And public school districts must enroll students in their district if they reside there. Doesn't matter if they have a disability, doesn't matter, anything else other than do they reside here? Do they lay their head in the district? If the answer is yes, then they go ahead and they enroll kids in that school. And this is the specific law that requires that. So for purposes of making determinations required under this section, the school district in which a parent or child resides is the location the parent or student has established as the primary residence and where substantial family activity takes place. So we know that, there are students who may have a parent's home where, maybe they live permanently with one parent, but then have parental visitation on other days. It's going to be the parent who has the custody of that child and where that substantial family activity takes place. So you could also have a circumstance where a family has, two different apartments. They're not, separated or anything, but two apartments made sense for them. And it's going to be at the one where more family activity takes place, so where more time is spent. Schools do usually require proof of residency upon enrollment in the district, and that's usually at the beginning of each school year. And so, Dustin, you want to kind of talk about some of the problems that arise here? Because
Yeah,
there are
sure. So
frequently.
you can kind of imagine in that scenario where, it's not entirely clear what the primary residence is, that the paperwork showing that could end up being a challenge. And some of the problems that arise is, districts ultimately get to decide what they require for enrollment, what sort of documentation that they're going to require parents to bring. There's not any specific documentation that is required as proof. For example, it's not, it must be a lease signed by both parties or something along those lines, although that can often be a useful piece. There aren't specific requirements of what documentation can be. There's nothing uniform across the districts. And so, it may very well be that, this last piece with the lease that, maybe you have a lease, but you're not named on the lease. And so the parent that's making the educational decision making and speaking with the district, registering the kid, enrolling the kid, name might not be on the lease. Oftentimes landlords are not as careful as they should be. They don't have someone listed as an authorized occupant, even though they are, for example. So then you might need to be looking for other records to establish that. Maybe utility records is a good one. If your name is on the utilities, potentially credit, but utilities is certainly a better one because it's more established to the location specifically. So the fact that there isn't a set number of things that must be accepted can create problems, but generally most people do have the ability to gather documents that would satisfy the districts. So that's kind of my take on that area. But if you're running into difficulties with a district accepting the documentation that you have available to you, this is an area where reaching out to counsel can be helpful. Reaching out to attorneys, whether that be a private firm like the one hosting us here, or if you qualify for services, whether that be someone like legal aid.
I can give a great example from my time, assisting families in enrollment and school things here. So one of the things, like I said, I do domestic law, and there are times where families, they were married, they are still married, yet they are separating. And, one parent has the residential marriage home, the home that they, jointly own in some form, but only one parent is there. And then the other parent moves into a different apartment in the same school district, yet in a different elementary school zone. And I had to help that parent communicate with that school district about, hey, I understand that the address you had at the beginning of the year is a different address, but I'm having to now drive my students every morning to their old home, have them get picked up and dropped off there, and then having to drive there at the end of the school, pick them up and take them home, instead of them actually getting picked up where they actually reside in the apartment. And she was having trouble with communicating to the school, like, hey, I live in this apartment. It's not fraud or anything. I live here because we're separating, but we're not actually divorced yet. We haven't even filed for divorce and we're not ready to, but I need my students picked up here because they live here. And initially the school was resistant to that because there was, only limited documentation on some end. And so, she talked to me about it. I was like, oh yeah, that's something that's easy for us to take care of. And they have enrollment specialists at districts, and, the attorney, me, in that circumstance, all I had to do is talk to that district staff there, and we were able to overcome that barrier to enrollment and transportation essentially. But those are things where, they can just kind of get sticky sometimes, and an attorney may be able to help you get unstuck there, whether it's just through like, hey, this is the type of document you need to give them, and so you should do that, or a little more where, the attorney may be able to speak for them. Another situation I've seen is, again, a separation. Like I said, I do divorce law and custody, so these things happen frequently in those cases, but where a parent was leaving the marital residence, but then living with her her mother, and it was her mother's apartment. It was, you know, the family's, permanent place. It's just she was not on the lease, even though she was part of that living unit essentially in that apartment. And so that parent was struggling getting the school to enroll them at that new school district because they said, oh, well, you don't have a lease, so you can't live there. And that's ultimately, as Dustin knows, even if your name's not on the lease, you can still live there legally speaking, if as long as there is somebody there whose legal name is on that lease. So if there are any questions about this, please feel free to put them in the chat there. So what happens, if your student isn't attending school? This is something that we have started to see more and more, especially post-COVID, because we know that COVID did make it, did increase absenteeism for students at school, generally speaking. But there's also a difference between truancy and chronic absenteeism. So chronic absenteeism is about the entirety of how many days of school a student is missing, regardless of if it's excused or not. So a student could be chronically absent because of an illness. And ultimately, yes, they are chronically absent and that's a problem, but you have to address that underlying illness first. And so, you could be chronically absent because you're in the hospital, a lot as a student or as a family. And that's just something that can't be avoided. But, if it's not for something like that, chronic absenteeism becomes more and more of an issue. There's also excessive absences. So that could be very similar to chronic absenteeism, where there are 38 unexcused or excused absence hours per month, unless medically excused, or 65 excused or unexcused hours, unless there's a medical excuse. So excessive absences are more about missing school without an excuse. And then you have habitually truant, which are 30 consecutive hours without a legitimate excuse, or 42 hours per month without an legitimate excuse, or 72 hours per year without such of a legitimate excuse. And the habitually truant is this place where people start getting more and more concerned and into more legal trouble. Truancy complaints can go to the juvenile court and are only submitted for habitually truant students. So for the first two, you don't necessarily face truancy issues. It still impacts your student and still impacts you, but not in that legal context in the same way as truancy. Now, truancy is technically a criminal process. So our office doesn't directly help with them, but we can help with the impacts that truancy may have in school. Schools must complete absence intervention before submitting a complaint to the court. So that's literally just a meeting with the family and the school about the truancy and about the absences, and figuring out, what can we do to prevent this from happening in the future. But if it continues to happen after that attendance intervention meeting, they usually will go on and file the truancy. Parents can also be charged with that, with a failure to send, which is a misdemeanor criminal offense, if the child is not attending school as well. And so, continuing on that, Ohio law requires schools to assign all habitually truant students to an absence intervention team. So when I was just talking about that absence intervention plan, this is the team that meets to discuss what those plans are. And those design a specialized intervention plan in an attempt to prevent that student from being truant in the future. Again, that is very important for them to do that before they go through and file the truancy. That team must include a representative from the school district, a representative from the school district who knows the student, and that student's parents or parents designee. And that team may also include, other people. It doesn't have to just include those people. It can include psychologist, counselor, school, social worker, representative from a nonprofit. It could be an attorney. I always suggest getting people like psychologists, social workers into these meetings to help get a rounded perspective too. So it's not just you and the school. It's also you, the school, and a outside party who may also be able to contribute information about, what's causing the truancy here, because oftentimes we know that truancy is not just the student not wanting to go to school. There are bigger reasons why students don't want to go to school, which we are going to get to in a minute, from disabilities to bullying, to just not even seeing the value in school, bluntly. So, Justin, do you have anything to add on this?
Not so much other than, kind of what's coming up on the next slides, but I think thinking of that holistic team is kind of crucial to understanding what the point of this absent intervention team is. The first three required levels don't really make it holistic in a way that's going to, by itself, maybe address the issue, unless the school chooses a representative that is, in fact, a school psychologist that has regular contact with the kid or something like that. But those three on their own might not be enough. So I think looking to bring someone in from your own team that works with your child regularly and is helping with them with these very same issues that they're facing in school, but in outside community environments or at home, can make everything work better, not just at school, but at home, and make life easier for that kid and make that kid actually, want to attend if that's part of the problem.
And, one of those big problems that we know students face, is when students are facing homelessness, because, students facing homelessness have unique sets of issues that make it harder for them to get to school. And so here, that's why the McKinney-Vento Act was passed and is such an important resource for all of you to know, because that act requires school districts to make sure that homeless students and their families have access to the same free, appropriate public education, including preschool, that other children and youth have access to. And so that means that the districts are required to remove barriers for these students to getting into school. And the definition of what experiencing homelessness is for this law is probably broader than you think it is, because it's not the traditional way that people think about those experiencing homelessness, where you're sleeping outside, or you are in a shelter. It's more than that. You're considered homeless under this law if you're lacking a fixed and regular adequate nighttime residence. That includes students who are living, for example, with aunts or cousins or other family members who are doubling up with them, sleeping on a couch, in their living room, sleeping on the floor in their cousin's bedroom, things like that, that are not that set fixed nighttime residence, where that person is essentially calling, is that person's place is that home. And so really pay attention to that, and just know that if you are, or if people who are experiencing homelessness or going through that housing instability, there are added protections for them. And so these protections are pretty wide ranging. So they will help you get transportation to and from school. They will help you attend your school of origin. So the idea behind this is, in a student who is experiencing homelessness in their life, they have an incredible amount of instability in their life. There's no sort of stable set of adults, stable set of routines that these children are having in their life. And so this act is creating some of that stability and allowing them to continue attending the school that they were attending had they not become homeless. And so that's where that school of origin, even if they no longer live in that area, because ultimately we were just talking about residency requirements and sending in things like leases, this kind of gets away from that, for the school district, saying, hey, if the student is experiencing homelessness and they leave your district, they can still attend school in that district that they left up to a certain point. And that certain point is reasonableness. Basically, for the transportation to and from school, I've seen it up to about an hour. That's about the limit where I've seen schools be willing to transport a student back and forth each day. So I think I had a student from Marion attend school in Southwestern before. That was about an hour drive there and an hour drive back. That is a long time. That's 2 hours in a car every day for a student. But for that student, that was very important for them to have that stability, have the same teachers, have the same classmates, in a moment where they had to go into a shelter. And so, so this is something to be very aware of. And every single school district must have a liaison, a McKinney-Vento liaison, homeless youth liaison, to ensure that not only the staff are aware of the students' rights, but also to provide families who are experiencing that homelessness access and facilitation for getting school transportation and other services set up that this act ensures that they have access to. And just know that, eligibility is fact specific. So if you're not sure, just ask. Liaisons are trained specifically to identify qualifying families and connecting them with the resources that they need. So don't feel like you cannot reach out to people for help in that, because that is their job. And I work with a lot of them and they're fantastic. So just know that they're there to help if you need it. Dustin,
And
do
I
you have
think the key
anything?
there is, when you're with a lot of parents, you may not think of yourself as homeless because you have that general definition of what you might have seen on television, or you might have gone through an urban city environment and seen people actually camping out on the streets, and you thought, well, that's homeless. I'm not homeless. I've got a shelter. It's not the shelter that was my consistent shelter for the last several years, but I've got somewhere. So I think part of it is just recognizing that this law is much broader than that, and that there's no shame in asking, and that if you're in a situation where your shelter is varied day to day or night to night, then that fits McKinney-Vento, and that fits the definition of homelessness in this category. And just making sure that when you're trying to enroll your child in a school, keep them in that school that they were in previously, that it's no shame at all to say I'm homeless under this scenario. Or if you don't want to say that, to say, I think McKinney-Vento applies. They're going to know what that is, and ask for the McKinney-Vento liaison if you're not comfortable with the phrase homeless, because it's, everyone's going to feel different about that. But I think making sure the school knows that, so they don't catch you in that process of trying to document the heck out of everything. They need to get moving on this and get moving quick with this particular issue. It's a nice area where you can bypass, at least temporarily, the administrative mess that is so many areas of law. But this is a nice one where you can shortcut it.
And it just, again, gets back to that stability. We know that stability is important for kids and routine, and this helps maintain that. So don't be shy in terms of using these resources if or when you need them. All
So
right, do you
I'll
want
start
to?
with this one.
Yep.
Yeah, attendance in special education. So there's some really unique areas here, and this is where I think oftentimes getting a lawyer involved becomes more necessary. Not suggesting that it's always necessary, but it is more common that it comes into play here. Because students exhibit, school avoidance behaviors for all kinds of reasons. They might be bullying, behavior, not seeing the value of school, as Anders brought up earlier. But if a student's avoidance of school is because of a disability, that's a situation where they want to make sure the school knows that the school has been informed in a clear as way as possible, that the parent believes, or maybe some private providers the child has, and explain to the parent, believes that this missing school is actually connected to the disability. Maybe due to anxiety in the disability connected, or maybe sleep issues that might be an issue with the disability that is causing late arrivals routinely. There's various things that could come into play here that could be causing the child not to attend school that are directly related to the disability. Now, a really kind of awful feature here, and Anders has this kind of in this last paragraph here, is often schools, and this has come up recently in some cases we've had, schools may not issue an IEP due to lack of instruction, is what they'll refer to it as. Meaning they haven't had the child in the school environment long enough for their experts to make a conclusion whether the school avoidance is due to, or whether the performance in school is due to missing school, just for whatever reason that's unrelated to disability, or that the performance in school is related to a disability. So it's sort of a catch-22 here, where the schools say, well, the kid's not been there often enough for us to make any real determinations or testing as to whether they have an underlying disability, whether that be ADHD, dyslexia, autism, any number of things, right? And the school may be saying, well, we just don't have the data because the child's not here. So this is when it can get complicated. And like, how do you give the school that data to make the conclusion that an IEP is needed? Because once the IEP is there, the individualized education plan. Once that's there, then there are a lot more pieces that come into play in terms of the school's responsibility to make sure that that child is attending. That make it fall a little more evenly between the parent, child, and school than just on the parent and child. So, what sort of things could you be looking at there? Well, maybe you're talking about private therapies that your child might get through occupational therapy, speech therapy, counseling, psychology, various things. Medical, if it is related to a sleep issue or something along those lines. That could help the school understand that, what, actually, maybe we do need an IEP earlier, and to not resist that as much, and not resist that evaluation or UTR process to get that as much. Do you have anything else on that particular issue, Anders, that you wanted to offer in? Because I know that there's a case I think you have a little more direct involvement in on that case recently. Things that have maybe helped that family.
Yeah, definitely. I've definitely had a number of cases like this. And, on one hand, I definitely understand, where the school is coming from, because essentially what they're saying is we don't know why. We can't say that the student is struggling because of their disability, because we think that it's them not coming to school. At the end of the day, I used to be a teacher, and if I had a student who came 2 out of the 5 days every week, and so they were only there 3 out of the 5, they were going to get behind probably. I definitely think that they would not, easily be able to keep up. However, I also do think that, there was a lot as a teacher that I'm not seeing about what's causing that student not to come in. And so, for in that context, that student, there's a certain cycle here that is kind of underlying, I think, a lot of the cases I see about that lack of instruction, because where schools are saying, oh, well, we can't rule that out, so we're not going to be able to issue the IEP identification or eligibility. And so that then causes a student not to have the services that they need. Not having the services they need at school then contributes to, not seeing the value in school, not getting the value from school, experiencing behavior issues, getting reprimanded more frequently, getting lower grades, and getting, essentially subjecting yourself to failure. So, I also understand on a student's, in a student's mind, why they would not want to come to school in contexts like that. I think about students who have autism. Autism can really impact sensory processing. And when a student is in an environment where, the sensory, they're getting a lot of senses that are causing them to overload, a lot of reprimanding from teachers, and not a lot of success, it makes some kind of sense why they would want to avoid that context as a child. Now, that doesn't mean that I think we as adults should just accept that. I think that's where we come in and we explain, hey, this is a circumstance where I'm concerned that the disability may be causing them to miss school. And like Justin said, one of the most important things that you can do, and helpful things that you can do, is getting services outside of the school environment from places. So, I mean, we have one of the best children's hospitals here in, I think, the nation. And we really encourage you to lean into that and in seek out that help from Nationwide Children's or from other professionals in that field, because they can then add color to what is actually happening, because the school is only seeing what's happening at school, and what you're reporting to them is happening at home. They don't see all the other stuff. And so having that outside, psychologist, professional, somebody who's, basically on your kid's side here in terms of explaining what's happening to them is going to be super helpful. One of the ways that I helped one of my clients overcome that is, we had in the IEP meeting, or the ETR meeting, where we were deciding whether or not the student who had school avoidance issues qualified for services. We had 2 different psychologists from Nationwide there, plus the IEE author there, who were all, basically on the same page as us, which was the students' disabilities causing their school avoidance, and we need to partner on all of that. And it's not just the home issue; it's home and school that needs to be working together on that. And so that's kind of how we helped overcome that.
And, getting there ideally before you even get to those meetings, would be nice. I think a lot of times these providers, as great as people at Nationwide are, and I completely agree with Anders, they're an outstanding outfit, especially if you're talking about the Autism Center or behavioral health, those areas. Not that there aren't problems. A lot of parents experience problems and they're real. But overall, excellent outfits, right? But any expert tends to think that their expertise is so obvious that other experts in different fields just should understand it or know it automatically. So I do find quite often that, parents will say, well, the psychologist has said this or diagnosed the child with this, or maybe there's a cover sheet, a note in a MyChart note, that gives some very basic detail. But there's not the conclusion drawn from these facts, right? That the school might actually be wanting to hear, or that might persuade the school. So sometimes this is where getting a lawyer involved can be helpful. Is not even necessarily in saying, okay, these medical psychologists and developmental psychologists, that sort of thing, need to come to the meeting. They may get to that, but short of that, it might just be helping them know what things they could point out in a letter or in a specially made medical chart note that really lays out these issues in a way that can't be missed, that doesn't require any knowledge from the outset from any of the school team members that might be looking at that IEP process. Because they're dealing with so many different things there that are there are two different ways of looking at the same scenario, right? And so helping the medical providers think in the way that the school providers might be needing to hear it. And helping the medical providers point to what evidence they have shows that there should be an IEP in this case that is addressing attendance. So that's, I think that's where a lawyer can sort of be the middleman or middle person here and help with that.
Other barriers that people face are transportation barriers. So, school districts are required to provide transportation to and from school. However, if you live within usually about 2 miles or less of the school building, the school does not have to transport them, with an exception, which I'll get to in a second. School buses do not typically enter apartment complexes totally, just because it's hard for them to maneuver. So it's usually the closest point of public access is usually how they do that. And school bus stops may be around half a mile away from someone's home. That's usually about the reasonable distance to the furthest reasonable distance to expect. So there is an exception where if transportation is required through special education. So I had a case where I had a couple students who live within that 2 mile radius. However, and they were in high school. However, they had cognitive disabilities that caused them to really struggle with wayfinding, essentially, and struggle with actually getting to school. And the school did provide them with transportation to and from their home, even though they were within that 1 mile area. Obviously, you can also think about, like, if you have a young child with like physical disabilities and you have to cross a big street by themselves, those are some barriers that can bring out transportation services. Dustin, do you have anything to
And
add?
amazingly, you actually have to fight those fights sometimes. Sometimes schools will be having children walk on the side of 6-lane roads that don't have an actual sidewalk but have a wide dirt area, for example, and say that's sufficient. And that's an incredibly disturbing interpretation of the rules, but you will see it. So I think there's a room for advocacy in that area as well. A little side note for this that people may have seen in the news recently, and it's a kind of common issue recently from some litigation, is required transportation in Ohio, which is really unique to Ohio, frankly, for community schools. So what would be called charter schools in most states, and for non-public schools that are actually chartered. So private chartered schools, registered with the state and chartered as schools. The local school district, your district of residence, is required to bus you in those scenarios. That's not quite as simple as that statement. There are limitations to it. There's a time limit to how far the ride can be. And then there's exceptions where the school district can say it's impractical under certain circumstances. But there is recently a handbook put together by the Department of Education and Workforce in Ohio that's readily available, and I can drop that in here if I can figure out how to do that. But ultimately, there is a handbook on their website that just came out in February 2025 that lays out all those details well. And it's an issue that is currently, I think it's still actually in the courts right now. So it's still being addressed, but some districts are wanting to fight it and wanting to be maybe a little bit more unreasonable in that regard. But it is a right that exists. So if you've had your child placed in a community school, you do likely still have a right to busing. And same if they're in a chartered private school.
All right, so we're going to move on to discipline here and focus on exclusionary discipline, which is self-explanatory. It's the discipline that results in students being removed from school. So just some, baseline facts. Every year, almost 3 million students in the US are suspended from school, causing them to miss learning time and opportunities to grow and succeed. Research is very clear that one of the factors contributing to the achievement gap is students spending time outside of the classroom. And when students are already academically behind, suspensions and expulsions already push them further and further behind. I have, hundreds of examples of that in my mind from the time that I've, worked in education, and really, I'm not a big, I always think like excluding a child from school should be the last resort. And, I think that a lot of people in schools agree with me on that, but I think a lot of people in schools also, take a little bit of a different approach sometimes. So thinking about, when can students be removed from school? So students are generally removed from school for violating the school's code of conduct. That code of conduct is, that book that students sign at the beginning of every year and that parents sign and definitely read every single page every time. I say that jokingly. I know people aren't really reading those things, but it is, I think, important to know, especially in this context, that they will be basing actions on the statements and the process in that book. And there are three types of removal. You have suspensions, which is a removal up to 10 days, an expulsion, which is a removal more than 10 days and up to 80 generally. And then you have emergency removals, which are, 1-day removals for safety reasons. So that's, hey, Johnny's really having a bad day today. Can you come and pick him up? And then you pick him up in the middle of the day and then move forward. A lot of schools don't count that as exclusions from school or a suspension or expulsion, but it is. When a school is calling you to pick up your child and have them take them away from school that day, that is a removal. Dustin, do you want to take this one?
Sure. So, there's a kind of a rubric or steps that a school has to take in this process of discipline. They can't just go straight up and immediately go to an expulsion, for example. They have to take different steps and provide certain types of notices. So in Ohio, a suspension is a removal from school for 10 days or fewer. This can only be imposed by the superintendent of the district or the principal of the school. But it can't just happen completely informally. Now, in practice, it is fairly informal quite often on the suspension side. But each of these things still do technically, well, legally, they do have to occur. So before a student can be suspended, he or she must be given a written notice of the reasons for the suspension, including the date, time, and location of the action giving rise to the suspension. So in practice, I think this is often very informal. Something might be as simple as it's written down or typed on a short, small sheet of paper and handed to the student as the process gets started, laying out a little bit of the detail, but there's not going to be a lot there on the suspension side. At least that's been my experience on most of them that I've seen for suspensions. It does tend to get more specific on the expulsion side. It certainly should. It doesn't always. It certainly should get more specific on the expulsion side. But the idea is that they're giving you something so that that student can prepare to defend themselves in some way and make decisions about what to do in responding to the principal or whoever may be talking to them about a potential suspension. The notice must provide the pupil student with the right to an informal hearing where he or she has the opportunity to challenge the allegation and or explain his or her actions. And, that's the language of the law. It sure sounds like that's a very specific right. In practice, that ends up being something along the lines of you're going to have a conversation in the office with the vice principal and maybe the principal. You're going to discuss, there's going to be questions asked of you after you've been given the written notice, and you have a right to respond to them. There's not like a specific way that may be done. There's not a right to a 10-minute response or a right to wait for 15 minutes and then come back with your response later. There's certainly not a right at this stage to talk to an attorney or anything like that at the suspension stage. So it gets, it's not as formal as I frankly would like it to be, but it does have to have some trappings of formality to it. It can't just be vice principal comes in and says, you did this, you're suspended for 10 days, right? That there has to be an opportunity to see in writing what it is, what you're being accused of, at time, place, location that it happened, and give you a chance to respond. And I think it has to be a meaningful chance, but that might be 5 or 10 minutes to respond. It doesn't necessarily mean you have a right to call witnesses or anything like that at a suspension stage, unfortunately.
And Dustin,
yeah.
And before you go on to expulsion, I wanted to pose this question we got in the Q&A.
Yeah.
This relates to transportation.
Sure.
So what if a child attends a residential public separate school and typically transportation is provided by the district of residence on Sunday evening and then Friday afternoon to go home? So Sunday evening transportation, Friday afternoon, so full week.
Mhm.
If the child on an IEP misses that pickup on Sunday due to illness or an appointment, the local districts aren't transporting the child on a different day, and the child then misses the entire week of school. And so I think this is in part a statement and then also a question as to how that might be handled by the local school district of residence.
Boy, I think it's going to get into the reasonableness question at that point. It depends on where this residential school is. The distance that it might be, how difficult or simple it would be to get alternative transportation on a later day. I could see that could be a pretty litigious question, really. I don't know that I have a clear answer for it. It's going to be very fact specific. I don't think the district automatically has a responsibility to come, a day or two later when the child is feeling better and transport the kid on that day. Now, if we're not talking about a very challenging transportation, or if what they do for transport is readily available any other day, if it's, for example, that they put the child on a regularly occurring route, that is, and the child just adds on to that route, then yeah, I think that's going to be reasonable at that point. But if they've hired out a private van to do it, and that van is only scheduled on those 1 days, and it's not practical to bring the van in on a different day, meaning it would be extremely more expensive, or that the van just isn't even available that day, they'd have to look into a different provider and vet that provider, for example. I could see in that scenario that it's probably the parent's responsibility to get the kid to the school those other days. So it's going to be very fact specific. Is that what you're thinking, Anders?
Oh yeah, definitely. I think the fact specific, it's like I'd have to know, I think, what the purpose of the transportation is, if it's just like because that's the placement, or if they need unique transportation. I think it's a fact specific problem. And I think the way you were thinking about it is the way that, I would think about that.
Now, if it's built into an IEP, that's going to be a fact in the child and parent's favor that maybe it needs to be done at the school's expense and rescheduling, because it may be that if it's built in the IEP, it often has safety reasons associated with it and special types of equipment in the transportation vehicle that's required, that sort of thing, harnesses, whatever it might be. And that might not be feasible in a private parent's vehicle, for example. So there are scenarios where that would weigh in favor of reasonableness. So yeah, very fact specific.
Yeah, thank you both. And for what it's worth too, I think if it's built in the IP, I think you can anticipate this problem and build in some workarounds if you had to. So
yeah, I think that would be a good way to think of IEPs in general. That is all too often not thought of, is to think of the contingencies as you go.
No doubt. Thank you very much.
Yeah, so going back to the suspension, and when you move on past that, so if in this scenario where you have some formality associated with it, but it's not extremely formal, It's a suspension stage. If that hearing, and we're calling it a hearing, but it's a meeting basically between often just the child and an administrator or a couple of administrative type people, maybe a school resource officer, that sort of thing. If that results in the student being suspended, the student's parents must be notified in writing of the suspension and to right to appeal within one school day. And in writing is crucial here, that it must be in writing. It can't just be a phone call. Oftentimes there will be a phone call, but it needs to be followed up in writing. Now, can that be email or letter? I suppose so, but it needs to, it's usually going to be both. But parents tend to learn of it first in phone call. At least that's what I'm seeing most often.
Yeah, and just note that the notice has to be provided to the pupil, not to the pupil and their parents, or pupil or their parents. It's to the pupil. Um, so just make sure that, if this is happening to you, that you talk to your student about, hey, what documentation did they give you, and following up with them. And like Dustin said, this is a very informal process. The hearing is a meeting in the principal's office where they talk about what happened and then move on. Kid's probably not going to even realize it's a quote hearing. And if you're there, which you're basically probably not going to be there because they don't really have parents at these suspension meetings, you wouldn't probably even notice it. You wouldn't probably even call it a hearing because we think about hearing, we think about judge, we think about lawyers and all that. This is
At
not
least an
nearly that far.
arbitrator.
Yeah, at least somebody impartial, but that's not the case here. And then then the parents do get notified after that hearing. So you don't get the notice, the pupil gets the notice of the hearing as it's happening, but then you get the notice after the hearing of what happened. So so you don't necessarily have a right to like be involved in the suspension hearing, but that does change when it moves to expulsions here. Anything else on suspensions before we move to expulsion?
Yeah, I think the only thing I was thinking is that, just because they don't have to notify parents of a suspension stage hearing doesn't mean that that's how every school will play it. There are quite a few that will notify parents, but that doesn't mean they're going to give you time to really respond. If you don't happen to be available, they're going to deal with this right away. The suspension hearing, such as it is, happens within minutes or hours at most of the incident itself. So they're not going to delay it a day or two for the parent to be available, for example, even if they are giving the parent that sort of notice that's not required.
Yeah. And so, like Dustin said, these things happen really quickly. So you need to be on top of the deadlines in these cases. Otherwise, they will pass you by within a couple days. So in Ohio, along with a suspension notice, if a student is being recommended for expulsion, there's also an expulsion notice. So you should be getting, both of those. And so an expulsion is a removal from school for 10 days or more. And before a student can be expelled, he or she and their guardian must be given a written notice for the reasons for the expulsion. And so that's going to be, if it's a Columbus City school student, it could be like a expulsion notice for a level 3 code of conduct violation under assault. For example, if a student got into a fight. And so that written notice is provided to the family explaining that they have a opportunity to appear in front of the superintendent, and that the time to appear would be between 3 to 5 days after that notice is provided to the family, and whether permanent exclusion is being sought. The notice, like I said, will include the reasons why. And then the parent or guardian, and if they have legal counsel, their legal counsel are able to present their case of why the student shouldn't be expelled or advocate for an alternative outcome. So one of the alternative outcomes we frequently suggest families to do, especially in circumstances where a student is going to be expelled. It's not a question of whether they will be expelled necessarily. It could be a question of, well, I asked that the student be expelled for 40 days, but be held in abeyance pending any other issues. An abeyance agreement is an agreement between the school and the family saying that if there's any further behavior issue, we will impose the expulsion that we imposed here but they pause that expulsion. So they pause the expulsion unless something else happens. If something else happens, then they impose that expulsion from then, and then they move forward with it. So those are things that you can, request in these hearings where, if you know that something, the student made choices that led to a violation of code of conduct, a fight, something like that, that's going to cause them to be expelled. You can always ask them for things like an abeyance agreement, or reducing the number of days from, 80 days to 40 days, depending on what's happening. And that's where the advocacy is going to be, I think, super important for an expulsion to be done. So if your child is going through an expulsion, I definitely suggest considering legal counsel, whether that's, reaching out to legal aid to see if you qualify for our services, where we may be able to come in and represent you, or we may at minimum be able to provide you some advice for how to address the and make a plan to address the expulsion and at the hearing and moving forward from there. Do you have anything to add, Dustin, before we go to the steps to potentially reverse an expulsion?
Yeah, let's go to the next steps, and I'm gonna start running through these fairly quickly because I know we're at 4 or 5
Yeah,
minutes left at this
yep.
point. So let's talk a little bit about what steps can the family take to reverse an expulsion. I guess first off, let's be honest with this, and it's very difficult. It is, there are circumstances where it can be done, but this is a major uphill battle, and you'll kind of hear why. So families can appeal expulsion decisions following a district's imposition of it. Generally, these are done through the Board of Education of the school district, and those appeal rights are going to have to be included on the notice of expulsion, and it's going to lay down to you what those rights are and what the timelines are for those. And you got to follow those to a T, or you're going to lose that right. So it's very strictly followed. Unfortunately, in experience, most often the board is just going to decide and go along with the district's decision. That's to say, unless it's obviously a bad decision in a way that they're genuinely concerned that a higher level appeal is going to overturn it. And that's why I say it's going to have to be fairly obvious at that level, because the step above a school board appeal is to the common pleas, to the Court of General's jurisdiction in your county. So, for example, here the Franklin County Court of Common Pleas here downtown, that your child, which is the common pleas within the district that your child resides, probably for most people on this call is my guess. But it would be whichever county is the one in your child's school district. Now, appeals to the Common Pleas Court are under a very high standard. It's under the abuse of discretion standard. So abuse of discretion means that no reasonable court or no reasonable fact finder could have come to that conclusion without arbitrarily, unfairly, or unreasonably looking and applying the facts to the law in question. It's not that that's never found, it certainly can be, but it almost has to be that they explicitly ignored certain expert that came in and gave a very clear opinion that was uncontested, and they just chose to ignore it, and that could have an issue. Or they chose to ignore that 3 witnesses said, this absolutely did not happen, and only one said it did, and they were the one that said they did, but had all kinds of credibility issues. Things that are just obvious on its face. So that's a high standard. So if you think you're looking at appealing something like this is where consulting at least with an attorney is really a good idea, because you could be going down an incredibly challenging road with almost no chance of success. And if you do have the facts that equal a chance of success, having a lawyer there will help you put those together in a way that proves that chance, I think, exponentially, honestly. So I think that's a really important time to get a lawyer involved.
I have nothing to add. So,
Right.
So expulsions, after the expulsion, general education students who are expelled are not entitled to education services while they're removed. That's tough, but that's just the way it is. And other schools, you can't like unenroll that student and enroll them at a separate school, because other schools will have that information from the expulsion and they can refuse to enroll them during that expulsion. However, students with IEPs do have service, are entitled to services while they're expelled. However, if there's like an element of violence or weapons or something of that sort where it'd be a danger to students or staff, other students or staff, for that student to be in school, those services would be had in an alternative education setting.
And I would just say, with regard to not having being entitled to be enrolled in another school, it doesn't mean they necessarily couldn't be. Other schools don't necessarily have to say no because you're being expelled from one, you can't go there. In practice, most do that though. But a lot of the online academies, even the public online academies, will enroll kids that are expelled from a brick and mortar school. So if that's a route you're considering taking anyway, don't assume you have to sit out the whole expulsion first. You may very well be able to enroll in an online public academy. Let's see here.
And yes, yeah, so I see Mark unmuted himself.
Yeah, I think we've
if
basically run out of time.
yeah, we have like a couple more slides, but happy to adjust accordingly.
Yeah, yeah, you have another minute or so. I just wanted to give you the heads up that we're close to the end, but go ahead.
Yeah, so this slide is just about, you know, some of the required expulsion offenses like bringing a knife to school, criminal act that results in serious physical harm to persons or property, or making a bomb threat. Those are things that are very serious, and schools kind of have to take a step to expel there. Pre-K through third grade students are very limited in terms of what they can be removed for school from, but those like serious violent type of offenses and offenses that are a danger to other persons or property, making bomb threats, those are things that they can still be expelled or excluded from school. This is the last and most important thing that we do want to make sure we emphasize here. There are special protections for students with disabilities in being removed from school. So students with IEPs 504 plans can be removed from school, just like general education students, for up to 10 days. But at the 11th day of removal, a manifestation determination review is triggered. These are determining whether or not a student's action was a result of their disability, and whether the school's failure to follow an IEP, including a behavior intervention plan, directly caused that behavior. And so if either answer to that question is yes to the first or second question, then the school cannot remove that student necessarily, and must update the IEP. Now, they could remove them from school, but then they would have to place them in the proper setting. So, you know, we often see behavior specialty schools like St. Vincent's or Buckeye Ranch being a change of placement for students who have, you know, serious behavior issues that are a result of a disability. They may then have their least restrictive placement be changed to somewhere like St. Vincent's. And then families do have an opportunity to appeal those decisions through expedited due process with the state. We have the process laid out here for you, but we don't need to go into the details because the state has this awesome flow chart here. You will not be able to read that on here, but if you look on the slide, this chart is underlined and linked. So this is the link to that flow chart that should be helpful for you as you're starting to navigate that process. And again, the expulsion process is one where we highly suggest you reaching out to attorneys because we can help you navigate that process. You know, our whole job is process, and we can help you through some of that potentially. So, you know, we have, you know, thoughts, questions, comments, please feel free to share them. You have my contact information and Dustin's right here. And we really appreciate the time, Mark, and happy to answer any questions that are out there.
All right. Well, thank you very much, Anders and Dustin. That was fantastic. We will go ahead and email everyone who attended a copy of the slides, if that's okay with you.
Yeah.
And we'll also post the video of this or recording of this workshop within 2 or 3 days at the same URL where you register. So it'll be available if someone wants to rewatch it or watch it later. And then just the last thing before we go, our next workshop is on Monday, April 21st. This is the Science of Reading by ODEW. And again, that's the third Monday of the month. And it just thanks again, Anders and Dustin. That was great. Timing was perfect. And I appreciate you coming and joining the clinic today.
Yeah, thanks for having us and thanks for putting these clinics on. This is great for the community.
All right.
Thank
Thanks.
you.